Okay, guys, let us start with the class today. This is a test series batch, and I must say it is the most performing batch, right? This test series batch, okay? Out of 8 people that qualified, right? Almost 4 of them was from test series only, okay? So that is the most performing batch. Okay, so let us today start with the test series program, right? And the whole lecture will function something like this: that we will be talking about how this test series will function, what are the things that I will be giving you, I will be helping you out with, right? And also then we will go towards how that interaction or the copy evaluation will take place. Also I will be talking about 3 major issues with regard to test series, right? The first issue is that how do you write answers. Come sit down, बैठिए. 5:15 से आप लोग लेट हो गए हैं, कोई नहीं. Okay. Yeah, so the second thing I will be talking about is that what type of question that comes. Okay, and at the last I will be showing you some of the toppers copies, right? Just overall go through that how you can write and improve your answers accordingly. Okay, so that will be the whole structure of this class. Okay, so starting with the overall thing about this test series, understand it, right? The first is that we will have around 10 tests. Okay, and in that 10 tests, all of them will be full length. That is one thing that you must remember, that all the 10 tests would be the full length. It seems like sectional, but it is the syllabus which is sectional, not the test itself. Okay, so it will be a complete full length, 8 questions, the whole thing. Okay, then we will have 2 full length tests. So I will have what I will suggest you, that you first write those sectional tests, right? And save these 2 tests after or 10 days before prelims. 10 days before mains, sorry, okay, or in between, write these 2 tests as a final preparation. Okay, so that is I will suggest. However, you can give it earlier also, that is totally up to you, right? Second thing is that once you give the test, I will be checking this particular test completely online. Okay, I will check it 1-to-1, or if you guys come in offline classes, I will check in the offline classes. I will make you sit in front of me and I will check that test. Okay, no checking like I will check you and you go home. Okay? That will not happen. Okay, so it will be 1-to-1, very detailed discussion, right? Like for an example, you can have at least 2-3 detailed discussion. After that, you can go, you can say that okay, you check it and I will read it. Then that is also okay, because sometimes time constraint is there. If you have not studied other subjects, then the second thing is that try to give the test as per timing. That second number clause, right? But that is not mandatory. Okay. But one thing that is mandatory is that the test would be given after that particular date. Okay, so I have a fixed schedule. So beyond that schedule, the test will not work. Okay, I mean before that schedule, the test will not work, right? So the test has to be given after that schedule, anytime you want. Okay, it is for the whole year, right? So people sometimes who are not preparing even for the mains may give the test for the whole year. That happens. Okay, so that can be done. After that, this detailed discussion I have already told you. Okay, and second, that I will be interacting with you, right? Anytime you want. You can email me or you can WhatsApp me and I will be talking about it. Okay, now these are the things that I will be talking about. The first of them is the type of question asked. Which type of question actually comes in exam? Okay, the type of question that comes in exam. So if you look at the exam paper, right, then you will see that there are generally 4 types of the questions. Where is the pen to write? Give me a minute. So there are generally 4 types of question that comes in exam, right? Write down. The first type of question is a direct question. Now what do you mean by a direct question? So I have given you certain examples. Okay, there are 4 types of question, right? First is a direct question, then you have a direct plus a concept. Then you have direct plus direct. They interconnect 2 topics and ask you a question. And then there is a philosophical type question. So what I have given, that I have given the examples of those questions and how to handle it. If a direct question comes, how to handle it, okay? And sort of imprint it in the mind that these are the questions that is going to come and these are the answers I am going to at least write in them, okay? Now what is a direct question? Direct is simply a concept, explain it, nothing else. It is the most easiest type of question that you will find. There is a question and they simply ask you to explain it, right? The examples you can read. Explain the following: doctrine of innocent passage, dissolution of partnership, principle of unjust enrichment, various dimensions attached to it, right? So these are the questions which is completely direct one. This is the core concept. This is the knowledge that you have. That's it. Nothing else in that. Getting my point, right? Now the question is that how to write them. Okay. So the 5 things must be there. 4 things in that particular answer must be always present. Okay. First, obviously, you have to talk about that what is the statutory provision, right? Or what is the provision that is there in some international convention that is related to it. Like for an example, if you look at the first question, doctrine of innocent passes, the very first paragraph of the answer must contain the corresponding article. Mandatory, right? If there's a question with regard to, suppose, anything else, like let's take an example, for principle of unjust enrichment, Contract Act must be mentioned, so and so it have been given. Okay, so if you come through a direct question, the first thing must be there, that is the exact statutory provision that it contains in these and these or so and so part. Okay, now if it have been recently amended, you can cite those also, right? You can cite those also. Then you will write the second part, that is again in the introduction part, is the rationale behind that particular amendment. This part is very important here. Okay, what is the rationale behind that amendment? Why this amendment have been made? Okay, so this rationale part is actually quite important. Understand it very nicely. This rationale part is very, very important. Getting my point? Okay, that why do you need that particular amendment or that particular act? Why it have been there? Like for an example, the same question that I gave you example, doctrine of innocent passes. So you will start with the unclosed provision, right? And in this line itself, you will write this provision is the recognition of lawless or international border in the sea, which is very fluid in nature. So you're writing the rationale why these innocent passes have been given, because in international law there cannot be a very fixed boundary in the law of sea, right, or in any maritime boundary. So you cannot punish a person if due to some scientific problem his compass is not working or whatever, he accidentally goes into your territory. Okay, so this doctrine of innocent passage is the recognition of that particular limitations. Okay, now you need not to write the whole paragraph of the rationale, just an introductory part. Getting my point? Understood? Okay, like just unjust enrichment, the second question that we had. What you will write? The provision, and then you will go on straight away why unjust enrichment, right? Because a Latin doctrine that no one should be allowed to take benefit of its own wrong, right? So this is the recognition of that particular principle. Getting my point? So the rational part and the statutory provision must be in the introduction. Now the question is that when you are writing answers and you are unable to record those provisions, it means you are somewhere lagging in your content. Getting my point? Okay, understood, right? Then what you will do, that in the body you will write the different perspective of that particular question. Now perspective means what? Now that is a very broad thing, right? That will actually depend upon the question. So like suppose doctrine of innocent passage, the perspective would be what? Different sections or going into the detail or what are the major things with regard to doctrine of innocent passage. With regard to unjust enrichment, there will be multiple doctrine attached to it, including the case laws. Okay, right? So the introduction part, in the body part, what you will do, that you will simply expand what you have written in the introduction part. Getting my point? Understood? This PDF I will be supplying to you, okay? So you need not to worry. Then case laws, if that particular topic relates to a case law. Sometimes it might happen that there might not be much case. Okay, so in that case what you will do? You will simply skip the third point, you will simply stick to the second point. Then you will have to conclude. Now this conclusion is something which is, sort of, it will differ from topic to topic. Like for example, if there is a conclusion with regard to international law question, you have to write the direct one. Then what you will conclude? You will write what is the Indian provision for that, how India recognizes it, okay? Or if it is a, sort of a direct question related to law of tort, okay? So in that you can conclude with the recent developments, okay? If it is a direct question related to law of crime, in that you can conclude with recent case law. So even though writing in body you can conclude, you can give a separate heading saying recent developments, okay? And you can simply write the conclusion in that part. Understood that particular point? Like, or if some current affair that is in debate with regard to that particular topic, you can cite that in conclusion. Okay, recently, this have been in news due to so and so reasons. Getting my point, right? So the direct question must contain these three things. First, a statutory provision, rationale. Then in detail about that particular, the specific provision, right? If the case law applies, case law, and then the conclusion part. Yes, online people, are you getting my point or not? You can type yes in the chat box, right? And I will hear to it. Yes. Okay. Now let us come to the second time, and this question consists of almost in 250 marks you will find that at least 70 to 80 marks are direct question. Right? So almost 20% is a direct question, and the most easiest one, the apple, which is you can literally score a very nice marks in that. Okay, direct one. Examples I have already given. Now let us come to the second type of question that comes is with regard to direct and direct. They take two question, connect it. They take two topic and connect it. Let us see the examples of them. See, discharge of the contract includes breach of contract, but breach of contract not necessarily include the discharge of contract. Separate topic, but they want you to tell the interaction or the difference or the combination of them, or what is the meaning or why they are two are related. Like there was a question, constitutional separation of power leads to constitutional governance. There are two topics, but you have to write the connection between them. I think that question like this, extradition and asylum. Always this question come, repeated questions. Last year test series also had this question, right? In last year mains also this question was asked. Because this is something which they repeat after each 2-3 years, they repeat. This time obviously they are not going to ask, but most of the time they repeat this question, okay? So please get the like or the difference between this. So this is also two direct topic interconnected, right? So the differentiation also comes into the picture, okay? Now how to approach it? See, the purpose is that once you see the question, and if you know that what at least the body must have or what at least the introduction must have, so simply by looking the question, you should have an idea that what will be the structuring of the answer. What must be there in these answers, okay? So at that time you need not to think. You have to write 19 questions, right? So that time you need not to think, you have to simply come and write down. Getting my point, okay? Now let us come to this, how to approach it. So very simply, what we will do, you will simply expand on the direct question. You will write the two topic distinctively and explain the relationship between them. Simply write the concept of two topic distinctively. What is the meaning of discharge of contract? What is the meaning of, like for example, the first question you could have written, the discharge of contract means so and so, while this particular, of the innovation, what was the discharge and, breach of contract means so and so, right? And then statutory provision along with it, okay? And then you will go on and explain the interconnection between two. Okay, why breach is not discharge or vice versa, okay? And then you will write the case law to explain it. However, what is the answer of that question? Breach is not discharge, discharge is the breach. Achha, no idea, right? So you see, actually what happens when we talk about discharge of a contract, it means ki the liability have been totally, yes, discharged. Breach is something which partial liability have discharged. Okay, like for an example, the discharge of the breach of the contract would not be for the every provision of the contract. Like for an example, let me teach you also a little bit, right? For an example, I have a contract with you for teaching. This, this law optional test series. Suppose, let us take an example. Now, there are a number of things I told you. Suppose that is a contract document, right? So number of things I have told you. Okay, I will take classes, I will be checking your copies, one-to-one interaction will be there. I will be giving you whatever the model answer, whatever. Now, suppose tomorrow, I checked your copy, right? I given you model answer, but suppose two topics model answer I did not give you. Now the question is, can you sue me that there was a breach of contract? Right? Then the question comes that the breach of contract would lie against those obligations which are essential to the contract. So what is the essential to the contract? To give you test and check your copy, right? So I might argue, obviously it is a matter of argument, that non-supply of these two, this answer sheet might not amount to the breach. Okay, so it means only when the core function of the contract or the core of the contract I did not perform my obligation, then only it would amount to breach. Getting my point? Understood? Okay, right? So the breach of contract may lead to discharge, but not the other way. Understood that particular point? Okay, right? So that is something very interesting. Okay. Then what you do is that here the rationale between those two connections must be in the body, not in the beginning part itself. Right? Here the rationale between those two connections must be in body. Why that is so? Rationale means simply why. Getting my point? Okay. Now, when you have to conclude, then conclusion here should be a little bit different. Whenever you have a question where two topics is connected, always there is some jurist opinion with regard to it, or a case law which provides what should be the exact thing. Like for example, in the case of interconnection with international humanitarian law and humanitarian law, there is a jurist opinion that the boundary line between them is becoming thinner and thinner. So that might be a very good conclusion in the question when they ask you the differentiate between international humanitarian law and international human rights. Getting my point? Okay. So, so that should be written in the conclusion part. याद रहेगा ये point, ठीक है? It means कि when you have this direct plus direct questions, right, then each and every topic should be handled nicely. You cannot, pick and choose and say, okay, this topic I will handle and this topic I will not handle. Okay, like for an example, administrative actions are not always in conflict with rule of law, right? So we have administrative action at a separate topic and rule of law is a separate topic. Getting my point? So how you will start? You will simply define both of them. If any statutory provisions, you can write, even though not directly provided, indirectly it is a part of Indian Constitution, you might write, or it is a part of Indian administrative law, right? Then you will interconnect both of them, right? What is administrative power or actions and the rule of law? It is basically antithesis, right? Administrative action is totally based on the premise that administrator or the person who is exercising that power will act on discretion, and discretion is antithesis to the rule of law. Getting my point, right? So you have to explain that in the body part. You will not write this in the beginning itself. ठीक है? हालांकि sometimes what happens कि the answer is only one line. Okay? But you have to write 150 words. Getting my point, right? So you have to write that in the body part, and in the conclusion you might write multiple cases, or you might cite some juris that how these two needs to be attached to each other, how these two should be read in a harmonious construction. You might cite some jurist line, that's all right. Getting my point? Okay, right? So it means that when you have these two type of questions where two concept is connected, then both of the concept must be answered specifically. You cannot pick and choose, बच्चे करते हैं रूल ऑफ लॉ लिखना शुरू कर दिया, सिर्फ वही लिखना है सिर्फ, ठीक है? ठीक ना, तो वो नहीं करना. Yes, ठीक है? तो इंटरकनेक्शन, इट इज एंटीथेसिस, ठीक है? तो यू हैव टू राइट दैट लिंकेज. यहाँ भी नॉलेज इंपॉर्टेंट है कि इफ यू हैव नॉलेज यू विल बी एबल टू राइट इट डाउन. ओके, ठीक है? अंडरस्टूड. एक बात, वन थिंग आई ऑल्सो वांटेड टू से दैट इफ यू डू नॉट हैव this I mean, if you have lot of time and if you do not write some questions in test paper, because they have an option, right? So in that case I will suggest you that the questions that you have not written, at least think about it, what you could have written, because sometimes the question you skip in the test that actually comes in the mains. Okay, understood that particular point, right? So please keep that in mind. Okay, so this second type of question is over. Yes, online people also समझ में आई बात ये? Can I proceed further? Yes. Yes, Mr. District Agra. Okay, someone has written his name, District Agra. Okay, chale, now let us come to this type of question, and I think this question is something which requires a lot of knowledge from your side to write. Okay, what is this? It is, what they do is that they take a particular philosophical aspect and they connect it with a particular topic. A good line, full stop, discuss in the light of this provision of the Constitution. A good line about that particular topic, full stop, discuss in the light of unjust enrichment of the, like this question can be, no one man should be allowed to take benefits of his own wrong, full stop, discuss in the light of unjust enrichment provision of the Contract Act. So what they have done, they have given you a philosophical line and the exact direct part. Okay, now this type of question is basically what they want you, that you simply write about this part, okay, and this is the conclusion. Right? This question is asking, the question is about the direct question, but the conclusion should be the philosophical aspect. Getting my point? Okay? Meaning, suppose let us say question number 1, examine the concept of social justice as envisaged in the Constitution, more particularly in chapter 4 Constitution and article 14 of the Constitution, right? So the question is about these two. But what is the conclusion that they are looking for? That these two somehow assembles and leads to social justice. Getting my point? Understood? So in that, what you will write? Will you refer to the case law? The answer is no. Will you refer to the doctrines of equality? The answer is no. You might mention them, but you don't have to, sort of write what this particular doctrine says, what this particular doctrine says. You have to simply write in a single line, okay, there are multiple concepts of equality and which have been adhered or interpreted in the light of the DPSP provision of the Constitution, and that leads to social justice. Getting my point? Okay, right? So when you have this direct plus jurisprudential type of question, what you have to write in the intro part? This itself. Okay, this is the question, right? In the body and the conclusion part, you will actually examine these two provisions. Getting my point? The philosophical part. That is the body and the conclusion part. In the philosophical, this philosophical part need not to be written in the introduction only. Getting my point? Understood? Okay, right? So that is something you must keep in mind. Yes, tell me. Yeah, very correct. These two, these two, yes. How these two have led to the social justice. Okay. Four, major provision which leads to social justice and different aspect of equality, but not in detail of everything. 14, right? And then in the conclusion, that's yes, social, it is ultimately for social justice. That can be said. A lot of things can be cited. Very correct. Yes, legal aid can be cited. No, not at all. Okay, you have to begin with Article 14 and Article DPSP provision of the Constitution. How did they come about it? You can write the rationale behind having DPSP itself. The ultimate purpose of it was to give a positive fundamental right or positive reinforcements. Okay, and then in the body and the end part, you will talk about social justice. The question is not about social justice. The question is about Article 14 and DPSP leading to social justice. Okay, so you explain them and sort of present that how it have led to social justice. Getting my point? Understood? Okay. Similarly, if you look at this, globalization is a necessary evil. Okay? Discuss, examining the implication of the reform process undertaken by IMF by the structural statesman. Right? So this structural adjustment of the IMF and this IBRD is the question. Right? And how it is connected to the globalization. Globalization is an evil is not a question. Understood that particular point? Okay, so the structural aspect of IMF and IBRD is the question. That SDR, now how they are very much, badly given to the person. Okay, now the same thing I have written here, explain the question, right? And then body part, philosophical aspect, handle कीजिए उसको, ठीक है? Introduction में खास के philosophical aspect को, jurist opinion इसमें बहुत अच्छा होता है या Supreme Court judgments, ठीक है? कि what the court have said about it. ठीक है? देखिए इंटरलिंकिंग पे बहुत क्वेश्चन आते हैं, ठीक ना? तो इसलिए मैं कह रहा हूँ कि ये तीसरा टाइप का क्वेश्चन है, राइट? दैट इज द मैक्सिमम. ये क्वेश्चन जो है दैट इज द मैक्सिमम. ठीक है, तो ऑलमोस्ट 40% क्वेश्चन आपको इसके दिखेंगे. ठीक है, ऊपर के दोनों के क्वेश्चंस 20% दिखेंगे. ठीक है, इसके बाद जो लास्ट टाइप ऑफ क्वेश्चन आता है, ये बात समझ में आई एवरीवन? ऑनलाइन पीपल, आर यू गेटिंग दिस? यस, ओके. नाउ द लास्ट इज दैट the interesting type of question where there can be no one can say what will be the correct approach of this question. That is your philosophical one. No idea. No one knows. Right? Now that is, I think, the toughest to handle. Right? Now what are the examples of those philosophical questions? Now if you look at it, it says, public interest litigation is not the pill for all ills. It is, however, boon for the courts. However, it is also the duty of the court to prevent its misuse, elucidate. What they do actually, they take some good line from the judgment, full stop, and they write comment, elucidate, discuss. Now, I'm not going to go into the nitty-gritty of what is the meaning of comment, discuss, and that doesn't matter. That grammatical variation no one takes care. It is simply stupidity to sort of go into detail and try to frame your answer accordingly. Okay. In general, when the word discussion, it have a more of a positive tone, right? And if the word is critically or comment, it is more of a negative tone, right? Now, how do you define that tone in your 250 words? It is beyond the scope. It is very tough to actually define. You need to be a very good columnist or something like that to actually make some difference in between these two, right? But generally speaking, positive tone and negative tone, right? So that is what the difference is. Okay. Now the question is that how to handle these questions. Okay. So I have told the multiple approach, very fluid, anything you can do. But one thing that you remember that I have written in the last, this answer to these type of questions are actually a good article on the topic. That is the answer. You can pick and choose what you will write in what particular part, okay, and simply write it. Ordinarily, the starting should be with some very, very good lines about that particular topic. Like for example, in PIL, the Supreme Court in the recent years have transformed into themselves into the court and a court of the people, and they have allowed people from various sections to approach it unhindered by the technicalities of law. I just made it up, right? So something like that, a very good, emotional and sort of a very powerful line has to be written in the top. Right? So that is always a very good introduction for that particular question, right? And then if that question relates to a particular topic like that related to PIL, then you can talk about evolution. But in evolution, you will not spend and write the quiz laws related to evolution. Okay, this. No. Okay, simple evolution. 70s, habeas corpus was basically diluted, and ultimately, not ratio. What is that the name that? Locus standi was diluted, right? And ultimately, people were allowed, right? Then you will go on and write various aspect of it. I'm just taking the example of PIL, right? So what you will do, multiple cases are there. You will not load the facts. PIL, environmental part, these cases. Labor reforms, these cases. Family reforms, these cases. Okay? Yes, just simply write the name of the case in the bracket. Like life, this case. Life, this case. Yeah, the environment, this particular case. Like MC Mehta, you can cite multiple MC Mehtas. Okay? Nothing comes to the mind environmental or right MC Mehta. Any one of them will be definitely there. Getting my point? Understood, right? So that is a very tough case, the tough type of question to write, right? No correct answer, right? So what I do actually is that to handle these type of questions, if the question comes, I give you this, statement, good statement from the case law itself. Okay? Some very good statement, like there was a question when this 370 was, there, right? So very good, this concept of sexuality is a Victorian concept that remained thrusted upon the Indian people. Very good line. And that is Deepak Misra's line in the judgment, right? So I gave you in the last time, okay, this is the line if the question comes, and that year surprisingly that question also come, and that was almost a foregone conclusion because that was a very judgment which was quite in news. Okay, so make a habit of collecting those lines. Obviously, if you don't have time, I will supply them. Okay, so simply look at them. I will give you in that particular group. Okay, simply look at them, and there is a separate Telegram group on Telegram for all the students of law optional. Okay. Not the big group, the smaller one, name is law optional with my name, okay? That is the group, right? So you will be getting the links, okay? You come into that link, and I sent the article also in that particular link. Yesterday itself, I sent a very good article in that link, okay? Okay, you will get it, not to worry. Okay, now the question comes with regard to that, what do you need to see in writing answers? So I've given a very detailed lecture on that, but again I will repeat, because this is the batch of test series. The first thing that you have to see is the structure of the answer. Now when I say what is the meaning of a structure, it simply means, in a very broad concept, it simply means that you must help the examiner simply by a glance to see what is written where. It is very boring to read a very long paragraph. Can you read a long paragraph for a long time? No. Attention time is becoming so much smaller, and same thing is with everyone nowadays. Very tough. So simply by a glance, how will the examiner know that what you have written where? So the best hook is your headings. Getting my point, right? So heading is sort of a hook that you are giving the examiner this knowledge that this particular part of the answer is written here. Getting my point, right? So the first thing is that a structure means making it examiner to identify, e.g. for examiner to identify which part of the answer is fulfilling which demand of the question. Like take any example. Let us start with an example only. Let us take any example like this. What should be the best method for the appointment of the judge in the High Court, right? This is a philosophical question. They're asking your reason. So initially you write the constitutional pro a little bit. It have been a subject matter of debate, and originally the constitution intended it to be appointed by executive, but due to the political developments, the judiciary with their own courage or conviction, or you can write a more flexible word, judicial activism, right, led to the judges appointing being made by the judges, right? Then you write amendment of the constitution, right? That 99th amendment was struck down, you mention them. Okay, so that can be 99th amendment can be the heading. You write down what is struck down. Then you write down opinions. Your jurist opinion can be a heading, right? Okay, then you can do a comparative study. You can write a heading comparative study, right? Now when you write a heading comparative study, that doesn't mean that you have to also write comparative study with other countries. No, simply when you write comparative studies, it is automatically known to the examiner the comparative study must be with respect to the appointment of judges. Then you cite how the US it is done, how there is a judicial commission in the UK. That only we copied in our but the Supreme Court struck it down, saying that it is a national ANJAC. Supreme Court struck it down, saying that it is a violation of basic structure. Okay, getting my point, right? So it means the demand of the question, various aspect of that particular question is a different heading. Now that heading need not to be more than 3 words long. Okay, never ever do that. Have you seen the Hindu article having more than 3 words heading? No, 2 words. Very nicely they write 1 or 2 words as a heading. Make it bold. You also make it bold. Now make it bold means simply underline it. Okay, so that is a very proper part. Yes, online people, are you getting my point? Yes, you can simply type yes. I will understand that you are getting my point. Okay, good. Now let us come to the second aspect of the question. Second thing that you have to keep in the mind in the structuring part, is to make diagrams in certain things that you think is important, right? Sometimes it happens that diagram is important, there is no doubt about it, right? So in that case, making the diagram is actually good, especially in the case of criminal law. When you have to, make them understand what are the sections related to them. Like for example, with regard to fraud, in the case of contract also, your undue influence, right? So you have to make the diagrams, this plus this plus this. It leads to undue influence, right? Simply plus plus, not some caricature, simply plus this is equal to this. Okay, like for example, international law, when you have to, talk about custom becoming a norms of the international law. So custom, single arrow, crystallizes into international law, right? So instead of writing, if you make that diagram, that makes more presentable. Okay, but you don't have to make diagram like geography, obviously. Okay, so don't overdo it. That is why I have written it also, right? Now, what is the purpose? Obviously, it is to bring clarity. Now, the second aspect comes to the answer writing is the content. Now, content is something which I cannot teach you in the class. I mean, while checking the copy, I can obviously clear some of the concept if I have written it badly, but it is something which actually reflects on your knowledge. Okay, how much do you know about that particular topic? Okay, now this is here I am here to check mainly content. That is why in your copy also I will remark sometime that there is weak content. It means for that particular topic you are not writing the exact thing that is asked, but you are sort of hovering around writing stupid things, taking what popularly is known as Lord Hanuman approach, that you don't know a particular thing, then you take the whole, write the whole IPC. किसी में से कोई एक होगा, ठीक है? So you might feel like at the end of the day कि भाई मैंने खूब लिखा है, I have written everything, but the marks will not reflect into the same. Getting my point, right? So the content part, the refinement is needed. Okay. Now in that content part, you have to cite cases also sometime. So remember, case law need not to be cited with facts unless very necessary. Like Menka Gandhi you are citing, you need not to cite that passport was there. You are citing MC Mehta case, you need not to cite that there was MC Mehta, he was a professor and he started to do these things. No. Getting my point? So you have to cite one line in bracket case. Or you can cite case also, Menka Gandhi's case, comma, this. That's it. Okay, I mean, people make it a habit of other way also. Only the ratio. Only the ratio. You don't have to write the whole fact of the case. Never ever do it. Getting my point? Okay, it is a waste of time, right? As well as your waste of, this answer quality. Never ever do it. Okay, not needed at all. Okay? Okay. Then, when you, suppose you do not have so abbreviation should not be used. It should be avoided. Okay, you cannot write CONST. People generally do constitution, they write consti. इंस्टा पे नहीं लिख रहे हैं आप, ठीक है? यू आर राइटिंग ऑन द पेपर, ठीक है? तो कॉन्स्टी लिख के नहीं छोड़ेंगे. खास के जो नए बच्चे हैं ना, आप लोग न्यू स्टूडेंट, दे समटाइम टेंड टू डू दैट. नेवर एवर डू दैट, ठीक है ना? खासकर दैट ओल्ड प्रोफेसर्स टेक इट वेरी बैडली. ओके, एंड वंस द इमेज इज रॉन्ग कि ऐसा लिख रहा है, यू विल नेवर गेट गुड मार्क्स. ओके, तो नेवर एवर डू दैट. ओके, please keep that in mind. Okay, then the last part comes, which is I think again a very important thing for you guys, is the presentation. As I told in the last class also, that no matter how much you know, no matter how better writer you are, no matter how much knowledge you have, if the person who is reading is unable to comprehend what you have written, that makes no sense. क्या फर्क पड़ता है उसे, क्या फर्क पड़ता है? कोई फर्क नहीं पड़ता. ठीक है, तो आपका आंसर्स लेजिबल होना चाहिए. ये मैं बार बार बोलता हूँ, सेम चीज़ को रिपीट करता हूँ कि पीपल जनरली से राइटिंग डजंट मैटर, राइटिंग डजंट मैटर, बट टेल मी इवन वन टॉपर्स कॉपी विच डू नॉट हैव ए गुड हैंड राइटिंग. किसी का भी टॉपर की कॉपी उठा के मुझे दिखाइए उसकी हैंड राइटिंग अच्छी ना हो. मिला है कभी? ठीक है, तो इट डू मैटर, नो मैटर व्हाट द पीपल से. Right? Now handwriting matter doesn't mean कि you start improving handwriting, ऐसा नहीं होता है, but at least write something which is legible, दिख सकता है. ठीक है, दिखने में थोड़ा प्लीजिंग होना चाहिए, राइट? तो प्लीजिंग में क्या क्या चीज़ें हैं? तो पहला तो ये राइटिंग. दूसरी प्लीजिंग में चीज़ है कि इंपॉर्टेंट पॉइंट्स को आप अंडरलाइन कीजिए. ठीक है, जहाँ पे आप एम्फेसिस देना चाहते हैं. ठीक है, अंडरलाइन इट, बट इट डजंट मीन कि हर एक दूसरे लाइन में आप अंडरलाइन कर रहे हैं. Also that should not be work. Okay. तीसरा ये है कि पैरा, suppose you have to write a lot of things, right? So do not write a lot of things in just in a monotonous manner. Break it. 3 लाइन लिखिए, मतलब यहाँ से यहाँ तक लिख दिया आपने, ठीक है? यहाँ से दूसरा शुरू कर लीजिए, यहाँ तक लिखा आपने, यहाँ से तीसरा शुरू कीजिए, पेज की कमी नहीं रहती है बहुत पेज होता है ठीक है, पेज आप फुल नहीं कर सकते कभी, ठीक है। तो डू नॉट राइट लॉन्ग पैराज, ठीक है। किसी भी अच्छे लोगों की कॉपी 4 से 5 या 10 6 लाइन से ज़्यादा आपको पारा लंबा नहीं होना चाहिए, बड़ा मोनोटोनस हो जाता है, लंबा सा एकदम लाइन बाय लाइन लिख रहा है, नो नेवर डू दैट, ठीक है। मार्जिन से मत लिखिए, ये मैंने लिखा नहीं है इस पर, लेकिन ये बहुत इंपॉर्टेंट है, दे गिव यू नेगेटिव मार्क्स, ठीक है। डू नॉट राइट इन मार्जिन्स, स्पेसिफिक इंस्ट्रक्शन होता है, डू नॉट राइट इन मार्जिन्स, ओके। स्मॉलर थिंग बट इट डज मैटर, उस समय दिमाग आप लगाने लगते हैं। वर्ड लिमिट रिस्पेक्ट कीजिए, इसका मतलब ये नहीं है कि आप 200 नंबर 150 नंबर यू स्टार्ट राइटिंग 250 वर्ड्स, 165 हो जाए, दैट डजंट मैटर, राइट। मोटे तौर पे व्हाट यू फील लाइक that you count yourself ki how much line in a how much word in a line you write and how much line you write in one page, ठीक है। तो उसके हिसाब से you adjust yourself, that depends upon copy to copy obviously again, ठीक है। Sometimes people write very frugally, right, so they take long pages, but if you are writing very short and in a very precise manner, handwriting is good, 1.5 page for 10 marker is okay, 150 words, and around 2 pages for 2 and 2.5 pages for 15 marker, and 3 and 3.5 pages for 20 marker, right. So that is a general trend. Now if you write very small, right, so you can reduce it accordingly, that's all right. Understood that particular point? Okay, समझ में आ रही बात everyone? Online people also, are you getting this point? Vipul, Lenovo, Jayant, yes, okay. चलिए, now let me show you the important thing, that is your copies, okay. या विच पार्ट ऑफ द सिलेबस टू फोकस मोर, ये कोई मतलब नहीं है, पहले ये इंपॉर्टेंट था लेकिन अब ऐसा कुछ नहीं रहा, लेकिन फिर भी मैं थोड़ा सा बताता हूँ। कॉन्स्टिट्यूशनल लॉ में इंटर रिलेशनशिप पे फोकस थोड़ा करना है, ठीक है, एंड कनेक्टेड विद पीआईएल, खासकर टॉपिक नंबर 2 and 3 कनेक्ट विद पीआईएल, लीगल एड, पीआईएल, हाँ। Not a simple question will last for a year. No, not at all. Just read it simply like that you have be able to write an average answer. वो कभी डिटेल में तो सब ये कभी वो नहीं पूछते हैं आर्टिकल 15 क्लॉज 3 में बताइए, नेवर। दे आस्क आर्टिकल 15 इन जेनरिक, राइट, सो यू रीड आल्सो इन जेनरिक, ठीक है। नेवर गो इन डिटेल एंड स्टार्ट रीडिंग वेरियस ऑब्जेक्टिव ऑफ आर्टिकल 15 और वेरियस केस लॉ रिलेटेड टू आर्टिकल 15, राइट, यस, वेरी जेनरिक पार्ट, एंड दैट टू read those cases which have told us about the interconnection with these two. If you look at fundamental right, if I am going to teach you, suppose foundation in foundation batch, what I teach, I start with evolution of fundamental right. How it evolved? The initial phase, the court said that each particular article is a code in itself. One article has nothing to do with another article. Initial phase. Then the court said that no, this won't happen, right? Then we started to say that no, Article 14 had relationship between 15, 16, 17, right? Then the third phase came and we said that no, different provision of the constitution have interrelationship between each of them. So they started to talk about the interrelationship between not among the articles of fundamental right, but the whole chapter of fundamental right with DPSP, right? And from there itself the PIL, the concept of PIL evolved. Okay, so that philosophical part. Now this is such a generic thing that you can write in a question of Article 14 also. You can write that in a question of Article 21 also. You can write the same in a question of Article 19 also. Initially the court said that it is a code in itself, but later on it evolved and the relationship between them was found. Golden triangle is one of the second phase of relationship. Getting my point? Okay. Then in the fundamental right, I will go on and talk about the first question, that against whom it is there. So state little bit we will talk about. What will happen if it is not followed? So the concept of PIL I will be talking about. Or then we'll come to the third aspect of fundamental right, that what cannot violate fundamental right. It states what. So the law, the meaning of law under Article 13, that I will be talking about. Then I will come to the substantial part. So these 4 things related to fundamental right, the detail of each fundamental right is only the 1/4 part. But people focus mostly on that itself. ऊपर के 3 हम लोग भूल जाते हैं, जबकि क्वेश्चंस उससे ज़्यादा आता है। समझ में आ रही बात है, ठीक है ना? तो इसमें इंटर रिलेशनशिप पे फोकस कीजिए खासकर। अंडरस्टूड दैट पर्टिकुलर कॉन्सेप्ट, राइट? अब इसमें क्या है कि कुछ टॉपिक्स ये होते हैं इसके कि सिंगल क्वेश्चन आते हैं, ठीक है? लाइक फॉर एग्जांपल इमरजेंसी प्रोविजन में ये आता है डिस्कस, पिछले बार फाइनेंशियल इमरजेंसी पूछा था, ठीक है? तो क्या कुछ नहीं है क्वेश्चन, इट इज डायरेक्ट क्वेश्चन, कंसिडर प्रोविजन लिखना है, खत्म, कोई केस नहीं है, कुछ नहीं है, नथिंग इज देयर, ठीक है? उसी तरीके से अमेंडमेंट में केशवानंद भारती प्रीवियसली दे यूज्ड टू आस्क various aspect of Keswanand Bharti. Now they are simply asking basic structure and their interconnection with other part. जैसे पिछले बार the question was basic structure and preamble. Question, what are the part of basic structure is given in the preamble, ठीक है, then secularism is a part of basic structure, right? So they ask different principles of basic structure rather than asking the basic structure in a whole, ठीक है, तो अब उसे उतना डिटेल में पढ़ने की जरूरत नहीं है, अब केशवानंद भारती को ऐसे कुछ नहीं पढ़ना है। हाँ हाँ, उसकी अब जरूरत नहीं है कि हम, लेकिन बच्चे अभी भी कितना मतलब गलत है, अभी भी वो करते हैं, शुरू करेंगे है ना शंकरी प्रसाद से, वो लिखेंगे क्योंकि पढ़ा है ना, माइंड फ्रेम बना हुआ है कि वो लिखना है, नहीं लिखना है शंकरी प्रसाद। बेसिक स्टेप पर क्वेश्चन पूछा गया है, वेरियस एस्पेक्ट या हाउ इट इज फाउंड इन प्रियम्बल, अब शंकरी प्रसाद और ये सब मेंशन कर देंगे तो क्या होगा, 150 नंबर का पेपर, 150 वर्ड्स आपको लिखना है, एंड यू हैव वेस्टेड 50 वर्ड्स इन सिंपली राइटिंग द नेम ऑफ द केसेस। सच तो वही क्या ना, 20-25 वर्ड तो हो ही गया, मतलब 10-15-20 वर्ड तो हो ही गया उसमें, समझ आ रही बात है, ठीक है, तो डू नॉट डू दैट। ओके, इसमें क्या है, ब्रीफ नोट पूछते हैं लोकपाल में, खासकर लोकपाल में पिछले बार क्वेश्चन आया था विथ रिगार्ड टू व्हाट इज द पर्पस ऑफ द लोकपाल, ठीक है, तो दैट वाज अ वेरी सिंपलिस्टिक टाइप ऑफ क्वेश्चन। ओमुंसमान बेसिक चीजें, देखिए ओमुंसमान लोकपाल एंड लोकयुक्त लिखा है बिकॉज ओमुंसमान गिवन इट इज ए यूरोपियन कॉन्सेप्ट वेयर बाय we had a situation, we have evolved a mechanism when a person within the department will try to help you. That is the meaning of ombudsman, friends of the people. So in that spirit itself, this Lokapal and Lokyukta was created. Okay, that is why you need to interconnect and read them. Okay, yes, very correct. Okay, similarly we will talk about international law. अब international law में पहले I used to tell कि okay ये ज़्यादा पढ़ो ये कम पढ़ो, अब ऐसा नहीं रहा, ठीक है, हर एक टॉपिक से इक्वल क्वेश्चन आते हैं। पिछले बार मैंने एनालाइज किया, जो टोटल 9 + 5 14 क्वेश्चंस थे इंटरनेशनल लॉ में, एक भी टॉपिक छूटा नहीं था, हर एक टॉपिक से एक क्वेश्चन था, ठीक है, यस, इन ईच टॉपिक देयर इज वन क्वेश्चन, तो यू कैन नॉट स्किप एनी पार्ट कि हाँ भाई ये ज़्यादा पढ़ लीजिए वो कम पढ़ लीजिए, मतलब कि सिलेबस पूरा पढ़ना है, ठीक है। अब मैं भी क्वेश्चन ऐसे ही सेट कर रहा हूँ, ठीक है, जैसे ये शुरू का 7 टॉपिक एक टॉपिक में होगा, तो मैं भी यही कर रहा हूँ कि एक टॉपिक उठाता हूँ, मुझे टोटल 19 क्वेश्चन बनाने हैं, हर एक टॉपिक से 3 क्वेश्चन बनाने हैं ठीक है, मेरा भी स्ट्रक्चर एग्जाम का एग्जैक्ट वही होता है, कुछ टॉपिक से तो 3 क्वेश्चन बनाना मुश्किल हो जाता है ठीक है, जैसे ये एक टॉपिक है एक्स्ट्राडिशन एंड असाइलम, क्या बनाएंगे क्वेश्चन, व्हाट इज द मीनिंग ऑफ एक्स्ट्राडिशन, व्हाट इज द मीनिंग ऑफ असाइलम, वेरियस कन्वेंशंस अटैच्ड टू इट, असाइलम एंड्स, एक्स्ट्रेडिशन एंड्स, असाइलम बिगिंस, इसके अलावा कोई क्वेश्चन नहीं मतलब उसी से स्टार्ट ही होता है वो, समझ में आ रही बात ये, ठीक है ना, तो ईच एंड एवरी टॉपिक इसके पढ़ने हैं, ठीक है। अब आ जाइए नेक्स्ट में, सॉरी, दैट इज योर लॉ ऑफ क्राइम। इन दैट दिस क्वेश्चन, दिस टॉपिक नंबर 1 थोड़ा सा फिलोसफिकल क्वेश्चन आता है, टॉपिक नंबर 2 में, बाद बाकी में डायरेक्ट क्वेश्चन आते हैं, ठीक है, सॉरी ये किस में भी प्ली बार्गेनिंग में भी फिलोसफिकल क्वेश्चन आता है, राइट। सो ये जो जनरल प्रिंसिपल है इसमें जनरली व्हाई इट इज वेव्ड, व्हाट इज द रैशनल बिहाइंड इट इज वेव्ड, ओके, एंड इसमें abolition of death punishment, an eye for an eye will make the whole world blind, there was a question in regard to that, any particular quote, और इसी पे मैंने कल परसों एक आर्टिकल भेजा था आपको, that is the question of individual sentencing, the court have said that this doctrine that we have in the case of Bachchan Singh, that need not to apply totally in a blanket manner in every cases, but it should be molded for individual sentencing, ठीक है। I've given a very good article, हिंदू में ये बड़ा अच्छा आर्टिकल आया था इंडिविजुअल सेंटेंसिंग का, अशोक कुमार बड़ा फेमस रिसेंट केस है उसका, ठीक है, तो इस बार उसकी संभावना भी आने की, मैं भी उस पर क्वेश्चन एक फॉर्म करूंगा, ठीक है, तो आई गिवन यू इन द आर्टिकल ऑफ हिंदू, ठीक है, तो प्लीज रीड दैट, ये वर्ड लिखिए इंडिविजुअल सेंटेंसिंग, ठीक है, 6 जून या 7 जून के उसमें हिंदू एडिटोरियल में आया था, ठीक है। ऑनलाइन पीपल, आई थिंक आई हैव गिवन यू, वो टेलीग्राम ग्रुप में आप लोग शायद आप लोगों को मैंने भेजा है, if you are not a part of it, you will be made a part of telegram group, okay, not to worry, you will be made part, okay। अब आ जाइए प्ली बार्गेनिंग में, मोस्टली वही क्वेश्चन आते हैं, इट इज ए ब्लड मनी, इट इज ए ब्लड मनी, व्हाट डू यू थिंक, ब्लड मनी या स्टैट्यूटरी प्रोविजन, इसमें इसके अलावा कोई क्वेश्चन बन ही नहीं सकता, ठीक है, तो आई ऑल्सो समटाइम फाइंड वेरी टफ टू फ्रेम क्वेश्चंस, ओके। चलिए लेट अस कम टू लॉ ऑफ टॉर्ट, द मोस्ट इजीएस्ट पार्ट। इसमें जो कंज्यूमर प्रोटेक्शन एक्ट है, ये कंज्यूमर प्रोटेक्शन एक्ट लेटेस्ट वाले भी आते हैं, ठीक है, यस, सो इट नीड नॉट टू बी द ओल्डर कंज्यूमर प्रोटेक्शन एक्ट, ओके, सो द लेटेस्ट प्रोविजन ऑल्सो, लाइव लॉ में उनका एक बहुत ऐसा ब्रीफर है, ठीक है, मैं वो आर्टिकल हर एक बार भेज देता हूँ, उसको पढ़ लीजिए, जरूरत नहीं उसके अलावा, बेसिक कॉन्सेप्ट जो कंज्यूमर प्रोटेक्शन का, द मीनिंग ऑफ सर्विस, डेफिनेशन ऑफ सर्विस, द ओल्ड कोर्स रिमेन्स द सेम, बट द न्यूअर थिंग, इन्होंने यहाँ पे कंज्यूमर प्रोटेक्शन अथॉरिटी बनाया, दे हैव मेड अ कंज्यूमर प्रोटेक्शन अथॉरिटी, एंड दैट अथॉरिटी बेसिकली कैन फाइल अ कंप्लेंट्स अगेंस्ट अ कॉर्पोरेट बॉडी ऑन द बिहाफ ऑफ द कंज्यूमर्स. पहले यह था कि कंज्यूमर वुड हैव टू गो इनटू द कोर्ट्स, बट नाउ द गवर्नमेंट विल गो ऑन द बिहाफ ऑफ कंज्यूमर टू द कोर्ट्स. ठीक है, तो वो एक नया रिसेंट एडिशन है. ठीक है, तो उस बात को थोड़ा सा ध्यान से वो जा सकते हैं उससे, वेरी करेक्ट. तो वो एक इंपॉर्टेंट चीज़ है. अब आ जाइए लॉ ऑफ कॉन्ट्रैक्ट में. अब इस लॉ ऑफ कॉन्ट्रैक्ट में इफ यू लुक एट दीज 3 लॉज, 7th ऑनवर्ड्स, 7, 8, 9, 10, 11, 12, 13, तो ये सब अपने आप में एक कंप्लीट एक्ट है, कोड है. ठीक है, तो इसको डिटेल में पढ़ने के बदला व्हाट यू डू दैट यू लुक एट द प्रीवियस ईयर पेपर. ओके, उसमें जो जो क्वेश्चंस पूछे गए हैं उसी कॉन्सेप्ट को पढ़िए, वही रिपीट होता है. नेगोशिएबल इंस्ट्रूमेंट एक्ट में दो ही आता है. ठीक है, चेक बाउंस का आ गया, या डू यू थिंक चेक बाउंस शुड बी क्रिमिनलाइज्ड और शुड नॉट बी क्रिमिनलाइज्ड, बस फिलोसफिकल एस्पेक्ट जनरली यही आता है. ठीक है, कभी कभी ये पहला टाइप का क्वेश्चन हो गया. दूसरा टाइप का क्वेश्चन कभी कभी आता है, दैट इज व्हाट इज द बेसिक कंटेंट ऑफ ए नेगोशिएबल इंस्ट्रूमेंट, या व्हाट डू यू मीन बाय नेगोशिएबल इंस्ट्रूमेंट, ओनली द बेसिक वन. ओके, मंडे इफ यू विजिट मंडे हियर यू विल बी गेटिंग दैट प्रीवियस ईयर पेपर, जो अपडेट करके मैंने यहाँ पे छोटी सी किताब होगी, यू विल गेट इट राइट. सो डू टेक दैट, और उसमें बिल्कुल देख लीजिएगा. ओके, हाँ, टेस्ट इज ऑन ट्यूसडे पे है, एंड मंडे आई विल बी गिविंग दैट पर्टिकुलर बुक. ओके, देन कम टू सीएलडी पार्ट. सीएलडी में मैं नोट्स सप्लाई करूंगा. ठीक है, टॉपर्स के इंटरव्यू देखिए, उस नोट्स के अलावा थोड़ा सा उसमें एड ऑन कर लीजिए. काफ़ी है. ठीक है, 16-17 पेज का, 16 तो मैंने ज़्यादा बोल दिया, 7-8 पेज का एक नोट होगा. ठीक है, उससे ज़्यादा नहीं पढ़ना है, मोर देन सफिशिएंट है वो. ठीक है, उसमें हालांकि इस साल का मैं कुछ उसमें ऐड करूंगा आपको, कुछ जो 10-12%. इनफैक्ट मैंने 2-3 लोगों को बोला भी है जो लोग टॉपर्स थे कि व्हाट यू डिड द ऐड ऑन यू टेल मी एंड आई विल आल्सो डू दैट द सेम ऐड ऑन. ठीक है, तो सभी मैं पूछ के आई विल डू द ऐड ऑन एंड आई विल सप्लाई दैट टू यू. समझ में आ रही बात है. ठीक है, ओके, तो सीएलडी वाला पार्ट छोड़िए, ऊपर वाले फोकस कीजिए, ये हम पे छोड़ दीजिए. आई विल मेक यू प्रिपेयर दिस. ओके, मैं नोट्स पास करूंगा, मोर देन सफिशिएंट होगा. ठीक है, अब आते हैं कुछ टॉपर्स के कॉपीज में. ठीक है, तो लेट मी शो यू सम ऑफ द कॉपीज. इसी में कॉपी होगा. हाँ, तो किसका कॉपी देखना पसंद करेंगे आप? हाँ, वही अच्छा वाला मैं दिखाता हूँ. रुकिए, ये बड़ा नहीं होगा, नहीं होगा, छोड़िए. चलिए इसी लेके देख लीजिए. अविनाश का अच्छा लिखा है इसने. अच्छा, ये भी इंटरनेशनल लॉ की ही कॉपी है. नहीं तो इंटरनेशनल लॉ में देखिए, तो पिछली बार भी हमने देखा था, दूसरा में दिखाता हूँ आपको. क्लोज ऑल टैब्स. अरे यार, सब तो इंटरनेशनल लॉ ही दिखा रहे हैं क्या? हाँ, टॉट कॉन्स्टिट्यूशन. हाँ, ये देखिए. अच्छा, इसी लड़के का अखिल का ही. ओके, हाँ, इसमें मैं इसी तरीके से फीडबैक देता हूँ, कंटेंट, प्रेजेंटेशन और स्ट्रक्चरिंग पे. ठीक है, अच्छा है, बुरा है, कैसा है. ठीक है, उतना ही आया, 260 है, 130 मैंने दिया. ठीक है, मतलब मोटा मोटी जो मैं दूंगा उतना ही आता है, मतलब न ज़्यादा, 10-20% का वेरिएंस होगा. लाइफ एंड लिबर्टी आर इनएलिएबल टू ह्यूमन एग्जिस्टेंस, डिस्कस इन द लाइट ऑफ 14, 19, 21 ऑफ द कॉन्स्टिट्यूशन. पहले तो ये बताइए किस टाइप का क्वेश्चन है ये? टाइप 1, टाइप 2, टाइप 3, टाइप 4? फिलोसॉफिकल. ठीक है, तो मतलब कि क्वेश्चन बेसिकली 14, 19, 21 का है, कंक्लूजन वो करना है. यस, ऑनलाइन पीपल, ये बात समझ में आ रही है आप सभी को? ओके, अब इसने क्या किया देखिए. अच्छा हेडिंग है, थोड़ा बड़ा है लेकिन चलेगा, मतलब लाइफ एंड पर्सनल लिबर्टी इनफैक्ट अपने आप में बड़ा वर्ड है, तो दैट इज ओके. ठीक है, आर्टिकल 21, नो वन सेट बी डिप्राइव्ड, सीधा सीधा लिखा है इन्होंने, आरसी के ऊपर एक लाइन में मेंशन किया है. ठीक है, हालांकि उन्होंने इसने गलती ये की है कि ये ट्रायंगल को एक्सप्लेन नहीं किया ठीक से. यहाँ पे ट्रायंगल इसने बनाया है लेकिन इसे को इन्होंने एक्सप्लेन नहीं किया कि व्हाट इज द इंटर रिलेशनशिप. वैसे आप लोग बताइए व्हाट इज द इंटर रिलेशनशिप बिटवीन आर्टिकल 19, 20 एंड 30 एंड सॉरी 14, 19 एंड 21. क्या है वो, क्या इंटर, वो बताइए. हाउ, दैट इज व्हाट आई वांट टू गो इन मच डीपर. हाउ? Mm-hmm. 14 is equality, and 19 is talking about freedom of multiple things. So, and it also talks about reasonable restriction. So, if a reasonable restriction to be imposed for the right of Article 19, that must satisfy the 14. That is the interconnection between 19 and 14. Now, if a reasonable restriction is imposed under Article 21 to take away your life and liberty, that particular restriction also must satisfy the condition of 14. And 19 is nothing but one of the facet of 14, because if you do not have a freedom to do the things that is given in 19, life has no meaning. ठीक है, तो ये इंटर रिलेशनशिप आपको क्या करना है, एक्सप्लेन करना है. समझ में आ रही बात ये, अंडरस्टूड? ओके, तो डिटेल में जाके डायग्राम बना के छोड़ देने से नहीं होगा, ठीक है, यू हैव टू गो इन मोर डिटेल. ओके, चलिए अब और भी आंसर देखते हैं, इसलिए मैंने इनको सिर्फ 4 नंबर दिया क्योंकि इट वाज नॉट अ वेरी यस आंसर. अब आ जाते हैं, what is the meaning of religious practice which entitles to be protected under the Article 25 of the Constitution. सबरीमाला जजमेंट आया था तो मुझे लगा ये क्वेश्चन पूछा जाएगा, लेकिन पूछा नहीं उन्होंने. ठीक है, तो इस बार भी मैं ये क्वेश्चन जो है दूसरे फ्रेम में मैं ये क्वेश्चन दूंगा, क्योंकि सबरीमाला के बाद उस पर भी क्वेश्चन नहीं आया है, बहुत ज़्यादा संभावना है कि उस पर क्वेश्चन आएगा. कंटेम्प्रेरी है ना, तो 2 साल पिछले वाले जजमेंट्स के भी क्वेश्चन आते हैं. ठीक है, तो इन्होंने इसको लिखा है, लेकिन इसमें एक एसेंशियल प्रैक्टिस डॉक्ट्रिन है. ठीक है, वो ठीक से उन्होंने लिखा है. इवोल्यूशन, आप देखिए यहाँ पे इवोल्यूशन ऑफ डॉक्ट्रिन नहीं लिखना है ना, सिंपल इवोल्यूशन काम चलेगा. ठीक है, नो नीड टू राइट द इवोल्यूशन ऑफ द एसेंशियल प्रैक्टिस डॉक्ट्रिन. वही मैं कह रहा था, यू मेक इट शॉर्टर, सिंपली इवोल्यूशन लिखेंगे, द एग्जामिनर विल अंडरस्टैंड कि इट रिलेट्स टू दिस पर्टिकुलर थिंग. हाउ? नहीं, हाउ डू यू डिटरमाइन एसेंशियल प्रैक्टिस, दैट इज द क्वेश्चन. यस, ऑनलाइन पीपल ऑल्सो आप हाथ उठा सकते हैं, आई कैन सॉर्ट ऑफ गिव यू, आई कैन अनम्यूट यू एंड यू कैन आंसर दिस क्वेश्चन. हाउ डू यू डिफाइन एसेंशियल प्रैक्टिस? तो रिवीजन ही हो जाए क्लास में. यस, नो नो नो, यस, कि इफ यू रिमूव देम देन द एसेंशियल कैरेक्टर ऑफ रिलीजन विल चेंज. Yes, very correct, very correct. But the point is that in a monotheistic religions, the essential practice is very easy to understand, because more or less it is same throughout the world. But in a polytheistic religion like India, like Hinduism, sorry, right, it is very tough to determine what is the essential practice. A practice might be essential for a particular religious sect of Hindu, might not be essential for others. Right? Then we started to challenge that this essential practice doctrine must be satisfied with some other conditions. Right? Then the triple test came, it must be known by a name, etc., etc., right? These 3 tests, right? That is the evolution he is talking about. That you have written a very good answer. Generally people, ये evolution नहीं लिखते हैं, ठीक है? So that is really a very remarkable answer. Okay, तो इनके स्ट्रक्चरिंग आप देखिए, इसमें प्रॉब्लम क्या है, यहाँ पे इनको एक हेडिंग चाहिए था. ठीक है, इंपॉर्टेंट लाइन इन्होंने किया भी है, नागराज. ठीक है, इसमें हेडिंग डाला इन्होंने. ठीक है, तो इट इज अ गुड आंसर, सीम्स लाइक अ गुड आंसर. ठीक है, लेकिन इसमें इन्होंने कुछ गलती की होगी ऊपर में. अच्छा, ये मोनोथिस्टिक या पॉलीथिस्टिक रिलीजन, ये बात इन्होंने मेंशन नहीं किया कि व्हाई दिस इवोल्यूशन वाज देयर. ठीक है, तो इसलिए मैं देखिए, मैं 1 to 1 चेक करता हूँ, तो ये मैं वहीं पे एक्सप्लेन कर देता हूँ. ठीक है, मैं कमेंट नहीं करता हूँ. ठीक है, तो मैं कॉपीज में आप देखेंगे कमेंट ज़्यादा नहीं होता है. ठीक है, क्योंकि मैं 1 to 1 चेक करता हूँ, वहीं पे मैं ऐसे लिख के एक्सप्लेन करता हूँ सामने में. ठीक है, तो बच्चों को याद रहता है. मुझे पूरी उम्मीद है कॉपी चेक होने के बाद में कमेंट कोई नहीं पढ़ता है जाके. ठीक है, पीपल डोंट जनरली रीड. ओके, तो यू हैव टू कम फिजिकली एंड गिव टेस्ट. ओके, ये इंपॉर्टेंट है. फिजिकली मतलब ऑनलाइन भी चलेगा, वर्चुअली भी चलेगा, लेकिन टेस्ट 1 to 1 चेक करेंगे. Reasonable classification doctrine has watered down the impact of Article 14 itself by placing a doctrinal limit on its comment. Philosophical question है, लास्ट ईयर क्वेश्चन भी है, रिपीटेड है. ठीक है, आई थिंक 14 में 16 में क्वेश्चन आया था. दिस एसेंशियली सेज कि by giving multiple doctrine of Article 14, the court have capped Article 14 itself. Now if the legislature have to use Article 14, there is an additional limitation that it must not violate various doctrines of Article 14. So what actually that doctrines have done, they have watered down the impact of Article 14 itself. ठीक है, it could have been ocean, but the court have said that no, it can be these rivers only. समझ में आ रही बात है? ठीक है, right? So this is a question sort of take executive saying that courts are doing something which is not very correct. ठीक है, so the phraseology of questions you will see in UPSC is more or less anti-judiciary. Just joking, but the tone of the question is mostly to support executive. Okay, this is a previous year question. It was asked in 16, but I have asked in 2021 test. I thought it will be repeated, but it was not. Okay, overall this is a good answer. The constitution must be subjected to fundamental constitutional limitations and fundamental right provided therein. It is not at the exclusion of the basic human rights. Discuss. ठीक है, this is a philosophical question related to constitutionalism. ठीक है, कि human right is one of the principle of constitutionalism. Okay, right? Sometime I also give you some bouncers. When you read it, you will not understand what this particular question is about. But the question is essentially with regard to the syllabus only. It will be never out of the syllabus. समझ में आ रही बात ये? मैंने जैसे ही बताया, क्वेश्चंस मैं ऐसे ही सेट करता हूँ. क्वेश्चंस आप पीछे लिख दिया. प्रीवियस क्वेश्चन मुझे याद ही रहते हैं कमो बेस. अब प्लस उस टॉपिक पे जो रिसेंट डेवलपमेंट हुए हैं, या जो मुझे लगता है कि रिपीटेशन की संभावना हो गई, 2-3 साल हो गया, अब नहीं आ रहा है. ठीक है. एक बार तो 19 में ना, 19 से 18 में एक क्वेश्चन तो एग्जैक्टली एकदम सेम हो गया था. बोन ऑफ कंटेंशन बिटवीन एग्जीक्यूटिव एंड जुडिशरी. मैंने भी यही सवाल पूछा था यूपीएससी में, ये सवाल. क्योंकि हुआ क्या था कि देयर वाज ए रिपोर्ट. ठीक है. इन दैट रिपोर्ट दैट लाइन वाज रिटन इन द वेरी बिगिनिंग ऑफ एन आर्टिकल. ठीक है. दैट इज अ लाइन ऑफ इन रे केशव सिंह. ओके, वही मैंने पूछ के कमेंट लिखा, तो एग्जैक्टली सेम सवाल आ गया 8 कमेंट. ठीक है. तो ऐसा नहीं है कि बहुत कोई यूनिक बात है, बिकॉज दे जनरली फिलोसफिकल क्वेश्चन वही देते, तो चांस की बात है ना कि कभी चांस आ गया. ठीक है. तो ये सारे के सारे पेपर मैं आपको सप्लाई कर दूंगा. ठीक है, इंडिविजुअली. अरे यार क्या कर रहे हैं यहाँ पे. इंडिविजुअली मैं आपको सारे पेपर सप्लाई कर दूंगा. कुछ ही पेपर हैं, इन्होंने सारे पेपर्स लिखे हुए हैं. ठीक है. तो एक एक करके आप सब देख सकते हैं. ये आई थिंक किसका है ये? हाँ, कांची का. ये भी अच्छा है. सी इज़ ए गुड. हाँ, इसको तो ज़्यादा नंबर है, इनफैक्ट ज़्यादा अच्छे नंबर है इसके. ठीक है. तो इसके भी आंसर्स आप देख सकते हैं. देखिए हैंड राइटिंग इसकी कितना बढ़िया है. एक ये भी तरीका होता है केस लॉ मेंशन करने का. आप इसको अगर स्ट्रेट लिखते हैं और ये लिखते हैं तो ज़्यादा प्रेजेंटेबल कौन लगता है? ये लगता है. ठीक है. तो ये भी एक तरीका है केस लॉ लिखने का. ठीक है. यूनिक तरीका है. ठीक है. अंडरलाइन के बदले आप ये कर दीजिए हेडिंग को. ठीक ना. तो इट गिव्स ए वेरी रिमार्केबल थिंग. ओके. किंग वर्सेस फिलिप. ठीक है. मैंने अच्छे नंबर भी दिए. देखने से अच्छा लग रहा है ये. समझ में आ रही बात ये. ठीक है. तो प्रेजेंटेशन पार्ट बहुत इंपॉर्टेंट है. हो सकता है कंटेंट पार्ट थोड़ा लैग कर रहे हो, लेकिन इतना अच्छा प्रेजेंटेड है ना ठीक है, कि नंबर अच्छे मिलेंगे. नहीं, हालांकि कंटेंट भी इसका अच्छा है, ऐसी बात नहीं. ठीक है. सी इज वेरी गुड स्टूडेंट एक्चुअली. ठीक है. अगर आप इफ यू विल सी हर जर्नी, 2 बार प्रीलिम्स नहीं हुआ. ठीक है. और 1 बार प्रीलिम्स हुआ और रैंक. समझ में आ रही बात ये. तो वैसा ही होना चाहिए. प्रीलिम्स हो रहा है ना आप लोग का वैसे कंफर्म? हाँ, तो फिर कोई दिक्कत ही नहीं है. ठीक है. तो ये सबको जो ना एक बार ओवरऑल देख लीजिएगा. उससे ज़्यादा की जरूरत नहीं है. ठीक है. उससे ज़्यादा की जरूरत नहीं. बस एक ओवरऑल एक बार देख लीजिएगा. इसके आंसर्स कभी पढ़ने हो. ठीक है. ऑनलाइन भी वेबसाइट पे पढ़ा हुआ है. नहीं तो और सारे अगर देना हो ऑनलाइन 2 ही 3 पढ़ा हुआ है, क्योंकि कुछ जो है ना कॉपी बहुत बड़े है, 35 MB का है. अब इसको अपलोड करना वेबसाइट पर थोड़ा मतलब समझ रहे हैं ना, बड़ा टफ काम है. डाउनलोड भी नहीं होता. तो जो छोटे हैं मैं एक साथ ये भेज दूंगा, एक उसमें डाल के गूगल ड्राइव के लिंक में. ठीक है. उसी ग्रुप में मैं भेज दूंगा. यू सिंपली लुक एट इट. समझ में आगे बात ये क्लियर है? ओके. तो 14 से टेस्ट लिखना है. ठीक है. पेपर 1 में 4 टेस्ट है. मीन्स कॉन्स्टिट्यूशनल लॉ में 2 टेस्ट हैं. ठीक है. फर्स्ट का 7 टॉपिक कॉन्स्टिट्यूशनल लॉ का, सेकंड का 7 टॉपिक एंड प्लस एडमिन लॉ. पेपर 2 है. पेपर 3 फर्स्ट 7 टॉपिक ऑफ इंटरनेशनल लॉ एंड पेपर 4 लास्ट 7 टॉपिक ऑफ इंटरनेशनल लॉ. ठीक है. उसके बाद आ जाता है आपका टॉट. एक पूरा पेपर है टॉट का. क्राइम एक पूरा पेपर है. CLD एक पूरा पेपर है. कॉन्ट्रैक्ट एक पूरा पेपर है. तो 4 और 4 8 हो गए और 2 फुल लेंथ पेपर है. ठीक है. तो कुल मिला के करीब 270-280 क्वेश्चन आपको मिलेंगे करने. उसमें वही 19 क्वेश्चन करने 190. तो अगर 200 क्वेश्चन आपने कर लिया और थोड़ा बहुत प्रीवियस ईयर के लोगों के आंसर देख लिए, तो इससे ज़्यादा मुझे लगता है जरूरत नहीं पड़ती है. इट इज़ मोर देन सफिशिएंट फॉर यू. समझ में आ रही बात है? ठीक है. हाँ भाई, ऑनलाइन पीपल, एनी अदर क्वेश्चन दैट यू वांट टू हैव? बताइए. टेल मी एनी अदर क्वेश्चंस. यस, आई शुड अनम्यूट. So if you want to unmute yourself, you can unmute and ask me the questions. Okay. If you do not have any question, right, what you can do that you can ask me personally also. My number है आप लोगों के पास. ले write it down. ठीक है. तो फिर से जैसा मैंने बताया, इसी बैच से सबसे ज़्यादा स्टूडेंट निकलते हैं, टेस्ट सीरीज वाले बैच से. तो इस बार ये कंटिन्यू होना चाहिए. ठीक है. ओके. तो इंटरव्यू से पहले मिलते हैं आप लोगों से. फिर हम लोग ऐसे तो कॉपी तो चेक करेंगे, उसके बाद ऐसे क्लासरूम में इंटरव्यू के बाद मिलते हैं. ठीक है. ओके, डन. चलिए, आप लोगों को कोई सवाल? अब वो मुझे व्हाट्सएप कीजिए पर्सनली, मैं भेज देता हूँ. कोई दिक्कत नहीं है. टेलीग्राम पे भेज दीजिए. टेलीग्राम तो है. हाँ, सेम नंबर. इट इज सेम. यस एवरीवन, एनी क्वेश्चंस ऑनलाइन पीपल? नो. ठीक है. चलिए, तो वाइंड अप करते हैं.